Yeah. All right. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning, council, and welcome. So we apologize for starting late after we said we visited for a while with the students, and I should know that it always takes longer than I say it will for us to get back in the courtroom. So thank you for your patience with and we do apologize. Mr. Shima, if you would please call the 10:30 doc.
Thank you, Your Honor. The first case on the 10:30 a.m. docket for Thursday, October 31st, 2024 is appeal number 126747, State of Kansas versus Javon Jermaine Ervin, Sedgwick County, briefs both sides.
May it please the court, Peter Meharry for Javon Ervin, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 128008 in the matter of Carolyn Sue Edwards, original action and attorney discipline, no briefs filed.
Madam Chief Justice, may it please the court, Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, present and ready for argument. I am requesting 3 minutes for rebuttal.
3 minutes, Brandon.
Thank you.
Madam Chief Justice, your honors, may it please the court. John Ambrosio on behalf of the respondent who appears in person. We are ready for argument. She would like to address the court after I finish my argument.
Certainly.
Thank you.
Thank you, Mr. Ambrosio.
Your Honor, that concludes the docket for the week of October 29th, 2024.
Thank you, Mr. Shima. Would now call 126747, State of Kansas versus Ervin.
May it please the court, Peter Meharry for Javon Ervin. I could reserve 3 minutes of my time for rebuttal here.
3 minutes is Brandon.
Thank you. This case comes before this court after my client was convicted of several charges, including the most severe being a felony murder charge. He was ultimately sentenced to roughly 60 years to life. And we've raised several issues that we believe showed that he did not get his constitutionally mandated fair trial in this case. I'll start with the first issue in the brief, and that deals with prosecutorial error. In this case, in closing arguments, the prosecutor brought up twice the fact that my client had a prior fleeing and eluding charge. That's particularly important in this case because the underlying felony for the felony murder charge was a fleeing and eluding charge. However, we don't believe that there was an evidentiary basis. While this issue came up pre-trial and the district court had ruled that the fact my client had a prior fleeing and eluding charge could come in, it actually never did. It came out during the interrogation of my client by the police. However, that interrogation was never played. Instead, they had Officer Nadalzo testify. And when he was asked whether or not he was aware that Mr. Ervin had a prior fleeing and eluding charge, he said he was not. And there was no other evidence to that fact. One of the cardinal rules for closing arguments is that your argument has to have an evidentiary basis. And so for that reason, there was none here, and it was improper for the state to argue it in closing arguments.
Don't we have to look at the next question and answer though, where the prosecutor refreshed the officer's memory?
But the next question was, were you aware he was on bond? It wasn't, were you aware he was on bond for fleeing and eluding?
But doesn't it all go together? I mean, isn't there enough of a question here or enough of an inference here to be drawn from the two questions in combination that it leaves at least the room for the inference that the driver was on bond?
I think it
or
certainly,
being eluding.
I think the only inference you can make is he was on bond on bond. You have to look at his actual answer. And I think to say there's an inference there, you have to ignore that answer where he says, no, I was not aware of it. The next question only talked about Javon Ervin being on bond and being concerned about getting in trouble for being on bond. It did not go beyond that. So I don't think you can make that leap to say, oh, it must have been bond for fleeing and eluding. And that's why we don't believe there is an evidentiary basis for the state to then, in closing arguments, bring that up to the jury.
But in
Yes.
terms of prejudice, it was, the defense counsel brought it up in opening.
Defense counsel did bring it up in opening, but it's still prejudicial for the state to bring it up in closing arguments as part of its arguments as to why he should be convicted. We think that when you paint him, my client, Mr. Ervin, as a repeat offender, and not just that he has criminal history, but he has done what the state he is charging him to have done in this case. As I said before, the underlying felony here was fleeing and eluding. And you paint him as a repeat offender who apparently did it once. And certainly the jury would be thinking he must not have been punished for it because he's out there again. And we can't let him go this time. That's the prejudice we see. I'm
But
sorry.
isn't there an objection that could have been made, a valid objection, that the question itself, are you aware that he had a prior fleeing and eluding, that it assumes facts not in evidence? And that, which is, it presumes that he had this prior conviction and there was not such an objection. I mean, it's kind of analogous to asking somebody, how long have you been beating your wife? You know, that assumes you have been. And so you say, well, wait a minute, even though the question was for a length of time, it assumes facts that are not in evidence. That wasn't made. So can we make that assumption then that he was, that he did have a prior conviction for fleeing and eluding?
I don't think when you look at the question, I don't think it assumes facts and evidence because it's literally asking, are you aware, were you aware he had a prior fleeing and eluding charge? I mean, that's not saying, you know, when did you stop beating your wife? That's not that question assumes you're beating your wife. And the question is, when did you stop? Here, the question literally was, are you aware he had a prior fleeing and eluding charge? So I don't think it assumes anything. And when he says no, we don't have an evidentiary basis to allow the state to bring it up in closing arguments.
But a prosecutor has, I mean, that's the rule. You have to have a good faith basis for asking the question. And that good faith basis was not challenged, was it?
No, it certainly wasn't challenged. This was an issue that was litigated pre-trial. But the fact that they asked the question doesn't mean when the witness says, no, I'm not aware of that they get to ignore the answer and then just make the argument in closing arguments. So that's why we believe it should not have been brought up in closing arguments by the state. And as I said before, we do think, given the facts and how the state charged this case, it was particularly prejudicial in this case. I would like to move on to a couple of the instructions that were not given, that were requested by the defense. We believe that those were important for the jury to be fully instructed on the law and how they should view the facts in light of the law they're given. Specifically, the defense asked for a definition of pursuit, and they also asked for a modification of the charge for murder 2, reckless second degree. They asked for those instructions, and the district court did not give them. It did not feel they were necessary. However, we believe that they were. In this case, the defense was not, my client didn't do it. Devon stipulated to being the driver that was involved in the accident that ultimately led to the death of another individual. His arguments at trial were more nuanced. His argument was that this is not the level of recklessness for reckless second. He basically conceded that this would be involuntary manslaughter, reckless involuntary manslaughter.
Can I ask you then, based on that stipulation, going back to the first issue and your prejudice argument, doesn't that sort of undercut that then? I mean, it almost seemed to me the prejudice argument was propensity, but if he's stipulating to being the driver, how would that prosecutorial comment be prejudicial?
He's stipulating to being the driver in this case, but I still think it's prejudicial when you bring in the fact that he has this prior fleeing and eluding and you're painting him as a repeat offender, somebody who's done the exact same conduct in the past and is now doing it again. I think that pushes the jury to convict him, not necessarily because of all the evidence the state wants to point to, but because they're afraid of letting this guy go. So I don't think the fact that he stipulated to being the driver here undercuts the prejudice from being, as I said, characterized as a repeat offender. And going back to the instructions, the other argument at trial was that the pursuit had ended before the accident occurred. And the defense was, because the pursuit had ended, there was this gap between the pursuit, the accident, and ultimately the death, that felony murder doesn't fit. So it's important that the jury be fully and properly instructed on the law and how that plays in this case. And the defense asked for those additional instructions. Without getting those additional instructions, we don't believe the defense had the ability to fully and completely present their defense so that the jury could take the facts and take the law and apply them and determine whether or not my client was guilty of the charges he faced.
The state argues that the way in which you added words to the definition of pursuit essentially was there to support your theory, but not necessarily to state the law. Can you address that criticism of your instruction?
I think the definition of pursuit did properly state the law. Defense counsel stated they got it from a Court of Appeals case, Escobar, which ultimately got it from Black's Law. And certainly, when you look at it and it states what they asked for, pursuit is the act of chasing to overtake or apprehend. Following is not chasing to overtake or apprehend. If the officers turned the emergency lights and sirens off, he was not in pursuit. I think that does accurately state the law because it does show that to have pursuit, you have to have, and this goes to fleeing and eluding, you have to have lights and sirens. You have to have an officer actively pursuing with lights and sirens. And when that is done, the pursuit is done. And here, I don't think it's disputed that the officers had turned off their lights and sirens. The officers had turned around. So the pursuit is done, and it was necessary for that instruction to be included to clarify and make sure it was clear the jury understood when a pursuit takes place and when it does. When you look at,
I think your words and in framing that are interesting because you said, I think it's undisputed. Isn't that the problem with that last sentence, the way it's phrased? Doesn't it take away a factual question that might exist?
well, I say today, I think it's undisputed because I don't want to put words in the state's mouth. At trial and closing arguments, the state did say the lights and sirens were off. The officer had ceased to pursue my client. I use generally qualified language a lot of times here, but here from the trial record, the pursuit was done before the accident occurred. So that's why this instruction, this additional language within the instruction was necessary so that the defense could say, this is the law, and we believe this accurately states the law, and this is how it applies. It's not good enough to just say, well, you can argue this in closing. You know, when defendants claim self-defense, it only works if they get an instruction. If they get up there and argue self-defense without an instruction, it's meaningless. That's why these instructions are necessary for my client's defense They're necessary so he can fully present that to the jury and fully argue those to the jury. The final thing I just, in my 20 seconds, I'll wrap up, is I do want to just say a couple things about cumulative error. Looking at how the prosecutorial error and the instructional issues kind of marry together to deny my client a fair trial. With the prosecutorial error, as I said, I believe that it's prejudicial to my client because it's painting him as this repeat offender who clearly hasn't learned his lesson, and the jury is going to hold that against him. So with that, you're undercutting my client, Mr. Ervin, at trial. Without giving the instructions that I've talked about, you're undercutting his ability to fully and completely present his defense. So at the same time, you're undercutting my client, you're undercutting his ability to give his defense. And combined, either individually or combined, we believe they denied him a fair trial. For those reasons, I would ask, as well as the ones in our brief, that this court reverse and remand this matter. Thank you.
May I ask a question?
Yes.
Concerning the cumulative error, you understand and you referred to our decision in Waldschmidt
Yes.
that if it's not clear error, it's not going to be included in the calculus under cumulative error. And could you you mentioned that one of the reasons for that is that the statute is less authority than the Constitution, which requires a fair trial. Can you relate that to the judge's duty to instruct appropriately?
Certainly, our position is, and I know Waldschmidt is relatively new, and this court has affirmed Waldschmidt since Waldschmidt. But our view is that a judge does have a duty. The statute says a judge shall instruct the jury. Judge has a duty to instruct the jury properly. And we believe if a judge fails in that duty and that denies a client a fair trial, that is a constitutional issue. Constitution trumps everything, and that mandates a fair trial, and it mandates that this court look at every error in the trial. That is the basis of cumulative error. So we believe it may not be clearly erroneous, but it's still a legal error that occurred during the trial of my client. He has a constitutional right, as many courts have said, not to a perfect trial, but to, at the very minimum, a fair trial. And you can only determine that if you consider all the errors at trial. Errors work together, as I've argued in this case. They can play on each other. They can enhance each other. Whether or not that's an instructional error, a failure to instruct where the district court has a duty to instruct, or prosecutorial error in this case, or an evidentiary error. So we believe that it is important that when this court looks at cumulative error, which is a constitutional argument, that it has to include all errors at trial.
You said, I think I heard Constitution trumps evidence. Did you mean the Constitution trumps statute?
I have meant Constitution trumps everything. So. Thank you.
Thank you. Mr. Gillette?
Thank you, Your Honors, and may it please the court. Assistant District Attorney Lance Gillette on behalf of the state. I will briefly address defendant's claims that were argued here today, and with a little bit of hope, I can reach the final issue regarding some of our jail credit case law. First, the state wants to make one thing absolutely clear. We do not believe there was any prosecutorial error in this case because the record, when fairly construed, presented evidence that the defendant was indeed on bond or a prior flee and elude at the time that he committed the crimes in this case. It is very simple, very clear. At worst, at the weakest, when looking at this evidence, it was an absolutely fair inference that the prosecutor was allowed to draw. Record volume 21, page 147. Detective Naldoza was asked, I'll omit the lead up about housekeeping, but he was asked, are you aware that Mr. Ervin, at the time of the crash on July 6th, at the time of your interview, he had a prior pending felony flee and elude case. No, I was not aware of that. Okay, well, in his interview, does he describe, being on bond and not wanting to get in trouble because of that? And the detective answers yes, or yeah, he did. The prosecutor followed up, refreshed your memory there. It's been a couple of years. The detective agrees, yeah. It is the state's position, again, that if this is not direct evidence of the fact that the defendant was on bond, that the interpretation of the only reasonable interpretation, frankly, that can be drawn is that that was that the defendant was on bond for a prior flee and elude. And then in regards to how those then came up in closing arguments, and I'll tie this into the prejudice prong here as well. It was mentioned briefly twice. The prosecutor mentioned at one point that the defendant knew he was in trouble for a prior flee and elude, and then a little bit later on mentions he's on bond for a prior flee and elude. That's it. That was consistent with the state's position throughout this case. The history showed that both parties knew that the defendant was on bond for a prior flee and elude. They expected it to come into evidence, as was pointed out. The defense even mentions it in their opening statement. This testimony comes about, but then the trial is shortened. There is not any undue attention at all put upon this very narrow scope of very narrow piece of evidence that was only admitted for the narrow scope about defendant's mindset. We were not trying to paint Mr. Ervin as a repeat offender. It was simply to show that he knew what he was doing. And the limiting instruction was given that in conjunction with that and consistent with the party's intention.
What was the discussion on the limiting instruction? Was that insisted upon by Mr. Ervin's counsel?
Yes, it was insisted upon by both. There was a little bit of a
because there really
difference.
wasn't a 6455 hearing per se, was there, prior to trial?
There was one. It was
Okay.
brief because everybody expected this to come in. Nobody really had a problem with it coming in.
Okay.
And then there was a joint request for a limiting instruction. There was only I believe there was one word that was disputed whether or not one of the purposes that it could have been considered for. But it was ultimately, a limiting instruction was indeed ultimately given.
And was the joint request as part of the instruction packet at instructions conference?
Yeah, it was a part of the instructions conference. I think it was part of the defendant's written instructions in this case, but I know it was part of the instructions conference.
And that would have happened before the evidence unfolded
No.
at trial?
No,
Or
that
did
came-
that happen after this exchange of testimony that you cited earlier in your presentation?
It came well after.
Well after.
It came after the conclusion of evidence in this case. So in addition to the state firmly believing that there was no prosecutorial error here, even assuming in some form or fashion that appropriately commenting on the evidence could be construed as error, and frankly, I understand that is basically the argument. There are interpretations that can be made about this evidence. The state's was fair. The defendant would ask that that wishes that there had been a different interpretation. That does not constitute prosecutorial error, nor was there any indication of prejudice here. On the two instruction issues, briefly, I'm going to start with pursuit first. I do want to make it clear that the defendant's requested instruction did indeed lack support almost at all, save the first sentence. There was an unpublished case cited where it was merely Black's Law Dictionary defining pursuit as, quote, the act of chasing to overtake or apprehend. That quotation, respectfully, from was obiter dictum or dicta in that case, as it wasn't necessary for the resolution of the case that it was cited in. But that's not the definition of pursuit that the defense have requested here. They asked for that sentence plus, quote, following is not chasing to overtake or apprehend. If the officer turned the emergency lights and sirens off, he was not in pursuit when the motor vehicle accident occurred. That's what was requested. Those instructions did not have a basis in the law. They did inappropriately emphasize the defendant's interpretation of the evidence, as continues to be reflected by the attempt on appeal to further parse out the steps and the seconds and moments in this case about when the pursuit started, when the reckless driving happened, when it ended, were there any intervening causes of the murder here. And respectfully, that instruction would not have been necessary because I think reasonable people can understand pursuit, nor would it have been appropriate due to its improper emphasis that would have given to the defendant's evidence in this case. On recklessness, that is a bit of a closer call. However, respectfully, the state still is not clear today. What exactly did the defendant want to be instructed upon as part of a reckless definition? Below, they pressed two different options: that the instruction be modified to read, a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that a result of the defendant's actions will follow, showing extreme indifference to the value of human life, or to somehow parse that out and separate it into two different lines and have the under circumstances phrase delineated as somehow a second element of the offense. Then now on appeal, they're suggesting that quote, the conduct must show extreme indifference to the value of human life. The state maintains this is a subtle but meaningful difference. If the jury had been instructed that they could only focus on the conduct in determining whether or not this killing was reckless, that's not right. That's not a correct statement of law, because the correct statement of law through the long history on second-degree murder on this is clear that tiptoeing into these waters gets very muddy very quickly, because what's important is the circumstances in which the reckless conduct occurs. That's more than just the conduct. It takes into account the circumstances. That's what differentiates second-degree murder from a different layer of manslaughter. That is the muddy water that the court successfully avoided in this case by not entertaining and grant, well, it entertained it, but it didn't grant defendant's request. So we agree, again, we maintain that there was not only no error, but that regardless of if there was any kind of error found, it has to be deemed harmless, regardless of what level of harmlessness review is applied. We would again, though, ask that clear error be applied to both. On the cumulative error, very briefly, the state again maintains there are no errors here to accumulate at all, period. There are none. There are no instructional errors that reach the level of clear error that could be included in the calculus. The cumulative error argument fails. If there are no other questions on those points, I would like to take just a little bit
I
of.
have a
Go ahead.
question. On the cumulative error analysis,
Yes.
under Waldschmidt, if there is no clear error, there is nothing to accumulate. But the duty to properly instruct is the court's. And so how does that relate to the constitutional right to a fair trial if we don't consider errors that we've found that were not clear error?
I think that the best answer that I can give is that while the district court does have a duty to properly instruct, clear error really embraces the concept of an instruction or a failure to instruct reaching a constitutional level of like a constitutional error. And it requires an error severe enough that it would reach or impugn a constitutional right in order for it to be accumulated in that analysis.
Let me ask you this then. Cumulative error of, let's say we have no clear errors, but we have 100 that are clear errors. And you're saying that even we should not consider the cumulative effect in deciding whether 100 non-clear errors can be considered to represent constitutionally an unfair trial. Never happens.
I think that, well, I don't know that in a case with over 100 individual errors happens, frankly, but.
But if we follow the Waldschmidt rule, wouldn't you agree? We don't consider any of them when deciding whether there's been constitutionally an unfair trial. It's just,
That's correct.
nope, we're not going to think about it.
That's correct. Under Waldschmidt, that is correct. And that is the status of the law
Does
today.
that satisfy the Constitution?
I think that it would have to be identified, and if there's a need for further briefing on this point specifically, I mean, we would welcome that, but.
Well,
I have to-
if an instruction is not clear error, is it error at all? Isn't that the rationale of Waldschmidt?
I think that is basically the underpinning of Waldschmidt. And so if it doesn't reach that level, it shouldn't be included in the calculus.
But it's clearly not correct.
Something may be not correct. Something may be not correct because the defendant wanted it to be not correct, or something may be incorrect because the parties agreed to do something for the sake of efficiency, or simply because they agreed. I mean, there are 100 reasons.
Can something be incorrect and yet not wrong?
Sure. I think the example I just gave about parties, I mean, agreeing to do something in a case, I struggle to find anything wrong with that, even if what they agreed to do is technically incorrect. I
But
guess
it's not the
there's certainly
parties-
nothing constitutional with that.
But it's not the party's duty to instruct, it's the court's duty.
That is correct.
And if we admit, and if inadmissible evidence gets admitted and there's no objection, that doesn't count either, does it?
No, it doesn't.
Just wanted to include you in the family discussion here.
But the court doesn't have the duty to submit evidence, correct? That's the party's clear duty.
But the court is the gatekeeper for evidence, and there can be instances where a court can preclude the admission of evidence, even if the parties try to admit it. Even if the parties tried to do so jointly, a court has the authority to preclude evidence in certain circumstances.
But if the court does it, it's reviewable, right?
I'm not certain. I think it would depend if the court does it at the party's whims, at the party's wishes, then it's not. It could be invited error. Briefly, if I could, just on the Hopkins issue, the state is not here to ask this court to reverse Hopkins, to find Hopkins is wrong, to find that there's necessarily anything wrong with Hopkins, other than that it ought to be limited to its facts. I think that the Fikert decision that is cited in the briefs from the Court of Appeals points out that Hopkins is noble. It has been the goal, I can state for this court, has been the goal clearly in this case. When you look at the journal entry and the guidance that was offered by the district court, was trying to do what Hopkins and the statutes want the parties to do, to make sure that the defendant is entitled to every day of jail credit to which he or she deserves, but not duplicate credit. There is no basis in the law at all for a defendant to be receiving duplicate credit. To reward multiple instances of bad behavior by double counting the time one spent in jail because their behavior has been so bad makes no rational, logical sense either. We would simply ask that this court revisit the Hopkins guidance, offer some clarification based on cases where we don't have such a clean factual pattern as existed in Hopkins. We would ask this court to follow the reasoning in Fikert. I think that the statutory amendment further bolsters the state's position here, that amendment was undertaken to try to maintain or fill in a gap, I guess, that was left following Hopkins. And that gap is, what do we do when we have complex cases with recidivist offenders with multiple cases pending at the same time? If there are no further questions, I thank this court very much for its time. The state would respectfully request that all of the defendant's convictions and that his sentence be upheld, including the jail credit which he has received.
Before you sit down, can I ask, you made reference to the instruction conference about the limiting instruction?
Yes.
And do you have a citation where you would point us to? I pulled it up real quickly because my memory was that there was kind of an objection from the defense, and it does look like you could say that the defense counsel was really arguing about whether to include the word identity. But he gets interrupted several times as he said, do we even need to give this instruction? So I'm trying to, if you have a clear place where defense counsel asks for it,
Ask for
the limiting instruction. Because I thought that was what you said that.
I believe that he
the
did,
parties
and
clearly did. And it does look like they had an email exchange about how to word it, which I guess you could infer from that. But anyway, if you have a record citation for that point.
I apologize that I don't write off, Your Honor.
Okay, we'll
I
just
just-
continue to look through that then. So,
In my brief, it looks like I cite record volume 22 is where at least part of the instruction conference occurred. But
and
I'm trying to recall, I felt like it occurred in two separate volumes here. It's
Okay.
escaping my mind or
I'm looking
citation
at
right now.
that volume, page 45 right now. So, okay, thank you.
Thank you.
Mr. Meharry, you reserve 3 minutes.
Couple quick points. With the limiting instruction, I think there was some discussion and some back and forth, as you said, about the language. I would also point out the instruction in the written request by the defense, and that's volume 2, page 149, does not have any language specifically to having a prior fleeing and elude. It only talks about having evidence has been admitted alleging the defendant committed a crime on a specific occasion other than the present crimes charged. So I think that the defense did have some issues with that, that I will admit the instruction conference, there was a lot of back and forth, so it's a little muddled.
Well, can you clarify for me, was there a pre-trial or during trial 6455 kind of discussion?
I believe there was, and I think this is the right. I may be wrong on this, but I think record 6, maybe there's some discussion. I've got pages 44 to 66. I believe there's a discussion about that. I think that's the right site. If not, I apologize. But this was brought up pre-trial. The district court did ultimately rule that it could come in, but as I've argued earlier, we don't believe the state actually did that when trial played out. The second thing, with regard to the reckless second instruction that was requested, and this is from volume 22, page 11, defense attorney said, my suggestion is that at the end of the definition of recklessness, you add that language of showing extreme indifference to the value of human life. That's what I thought my argument was in my brief. I quoted it, so I'm not sure. I'm not following where the change is, but that's what was argued below, and that's what I've tried to argue here. One comment with regard to whether or not a clear error is an error, whether or not you can consider it, and we talk about, well, if there's no objection to an evidentiary issue, we don't consider it an error. I think those are apples and oranges. And I say that because when you have an evidentiary issue, it's not necessarily just a legal ruling. There's a lot of discretion that we give district courts. They look at prejudice versus probative value, stuff like that. So without an objection, without a record, I don't think you can say it was error or not. I think instructions are different. The court has a duty to properly instruct the jury, and this court can say, as a matter of law, this instruction was wrong, objection or not. So I think that is a difference, and that's why, even though it may not be clear error, the failure to properly instruct a jury is still an error at trial and still should be considered. The only other comment I would have with regard to Hopkins and everything since they amended the statute. Why did they amend the statute? Because this language allows for double credit and they sought to correct that. What the state wants you to do is say the amended statute is the same as the old statute. But it's not. There's a reason why they amended it. The statute that was in place at the time of this case just says you get jail time credit for the time spent incarcerated pending disposition, period. It's not qualified. State, with Campbell, this court added language to the statute. The state wants you to continue to do that. They fixed the problem, but the statute is clear, unambiguous, and that's what this court said in Hopkins. That's why, like it or not, I know the state doesn't, you get double credit here. Thank you.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement. I will now call case number 128008 in the matter of Carolyn Sue Edwards.
Madam Chief Justice, may it please the court. Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, I have reserved 3 minutes for rebuttal. This is an original proceeding in attorney discipline involving the respondent, Carolyn Sue Edwards, who has been licensed to practice law in the state of Kansas since 1986. This matter comes before this court following a formal hearing involving 2 separate disciplinary complaints. That hearing was held in June of this year, and prior to that hearing, the parties entered into a stipulation regarding the facts in both of those cases, as well as the rules violated in both cases. Therefore, the hearing went forward only on aggravating and mitigating evidence. At the conclusion of the hearing, the disciplinary administrator's office recommended that the respondent's license to practice law be suspended for a period of 6 months, and that should be required to undergo a reinstatement hearing. The respondent requested that her license to practice law be suspended for a period of 3 years, but that be stayed for a 3-year probationary period. The final hearing report was issued on August 2nd of this year, and in that report, the hearing panel adopted the respondent's recommendation of a 3-year suspension, but that it be stayed for that 3-year probationary period. They did make recommendations of additional conditions that should be implemented in the respondent's probation plan, including that instead of tapering off the weekly meetings with the practice supervisor, that she continue to meet weekly for the 3-year period, that there be an additional requirement that the practice supervisor periodically audit her communication with her clients. And then it also recommended a specific amount of money that should be refunded to the client in what I'll call the estate case, one of the complaints. Neither party filed exceptions in this case, therefore under 228G, the findings of facts and conclusions of law are deemed admitted. However, the disciplinary administrator reserved its right to contest the discipline recommended by the hearing panel. And I do want the court to know that today I'm maintaining my recommendation that the appropriate discipline in this case is a 6-month suspension with the requirement of reinstatement hearing.
I have just kind of an evidentiary question to begin with. In the restitution, I guess they said restitution in the estate case, $40,986.25. Now, I've reviewed the timesheets, and that actually her numbers differ. I mean, how did the hearing panel come to that number? Do you know?
I am unsure how the hearing panel came to that number. The disciplinary administrator's office has not made any recommendation of reinstatement of restitution because of the matter of the probate cases where the attorney fees must be approved by the probate court. That has never been requested, as far as I know in this case, at least at the time of the hearing. There had been no request to approve, and it was $84,000 total that client paid, and there has been no request for any of that. I think it's the 46,000 is on her timesheet. That was not a contemporaneous timesheet. That's something she did through the disciplinary case, trying to go back and estimate what she was, I think on her hourly basis, what she put into that case. I'm unsure how the hearing panel, I don't have the final hearing report directly in front of me. I know that they maybe looked at that and the type of case that was done and the amount spent, but I'm not sure how they came up with that specific number.
Okay, and in that probate case, and as I went through and, you know, we have a copy of the retroactive billing summary or billing timesheets, retroactive timesheets. And, you know, for the amount of time, which I don't know, it was $43,957, so whatever that is. What outcome did the victims in this case, I mean, what, you know, there was all this review, meet with clients, but what actually was done?
The record will show that at the time that the respondent they hired new counsel, I think that was in maybe August of 2021, that they had Tim O'Sullivan come on, that there was no conclusion to the probate case. There had also, one of the things that they had requested was for a motion in order to correct the death certificate as it had the wrong social security number, and that had not been done at that time either. And so as far as an outcome for those clients, I don't know that there was any at the time that they had to get new counsel.
Well, let me put it this way, beyond reviewing things, what did she do for these clients for what was 84,000, but I guess, you know, okay, so you know, her retroactive billing timesheet shows $43,957. Beyond reviewing things, what did the clients get? I mean, what?
That's why I believe the hearing panel found that there was actual injury to the client, because that case kind of languished for quite some time. And in the exhibits in the or the disciplinary administrator's office exhibits, there's the email communication back and forth. Have you done this? Do we have an update on this? And there's really no progress in any of that
Right.
throughout that entire period.
I guess my bottom line is why should the clients, the victims here, have to eat $43,957?
And
Why did the hearing panel determine that?
And unfortunately, I cannot answer that question. I don't have a recommendation as far as the amount to be refunded to those clients. I think that that's a probate court question. I certainly think if this court were to review, this court could have the authority to make a ruling on that, but it had never been submitted to the probate court, who could review and say, here's the work that had actually been done, coupled to what she said she did, and whether that's appropriate under the probate code.
But where the fees weren't paid by the estate, they were paid by the victim, correct?
But out of the estate, I think they have one of the exhibits, the complainant, who was the client and the victim in the matter, kind of went through what they had paid through that process.
Through what process?
Through, well, and I don't have it in front of me, what exhibit number it is, but talks about how the exhibit makes it look that she's paying it out of the estate, out of some funding that she has.
He wrote checks without approval from the court
Correct.
in order to
Court.
pay these
Okay.
fees.
Correct.
I'm still trying to figure it. So how does the probate court get a jurisdiction over this money that was not paid? In terms of your recommendation, your lack of a recommendation on what to do about the money, I'm still trying to figure out how even the probate court's going to be able to fix that. Shouldn't there be something in your recommendation about how this person gets their money back if it wasn't appropriately approved by the probate court? I don't get this.
And if we were to go that far, I think what my recommendation would be, if none of it was approved, and therefore none of those fees should have been paid by that client.
But why wouldn't your recommendation be that she have to, before she gets reinstated, she's got to pay back the money?
And that was not something I recommended at the hearing panel. We didn't fully go into that amount of restitution. With the court's permission, a little bit of something that's outside the record were conversations with Mr. O'Sullivan, and that case was still ongoing. So there were ways in which the respondent, I think, could have filed a motion with the court asking for consideration of those fees at the time that the hearing was going on in our case. But I don't know that the disciplinary administrator's office is in a position to try and analyze what the probate court would have approved in that case.
And it is in the record, I mean, because there was some question, well, I guess you're saying there's something in the record that shows that this money was taken out of the estate. It wasn't paid for by the victims.
I'd have to look back at that exact exhibit that was submitted by the complainant. And I don't know that it says where she's paying that money from, where the
If there's nothing to show
complainant-
where it's paid from, then.
I think her exhibit suggests that it's coming from something that she had access to through the estate, or she is, and that could be an assumption that I've made looking at that exhibit. I can't recall which one it is. It's part of the complaint that was issued in that case.
Okay, thank you.
I'll jump in with a sort of big picture question. This case presents an anomaly, or that's how I look at it, that has come up again and again and again, which is respondent requesting a 3-year suspension and disciplinary administrator's office requesting or recommending a 6-month suspension. And obviously the difference is whether there's probation or not. So that leads to my question, which is it appropriate for this court in disciplinary cases to essentially consider the entire discipline as a package, or should we be determining the period of suspension independently of the secondary consideration of whether there should be a probation? Because if we do it the first way, it strikes me that it gets our suspension periods completely out of whack. At least that's my fear. Does that make sense?
It does make sense.
So I just would ask for your response to that.
And I can say, at least in this case, when I was looking at what is the appropriate discipline, I tried to look at past cases that may be similarly situated. And what, as we're looking at the facts that led to the rule violations, coupled with the ABA standards, what is the appropriate discipline? And in this case specifically, I actually looked back at In re Cupca, which was in 2020. That actually was a 2-year suspension. And after 9 months, she could seek early reinstatement. I looked at some other cases, but believed that based on this misconduct, in light of the significant mitigating factors, a 6-month suspension was appropriate. And then on top of that, I'm asking for the reinstatement hearing to ensure that there are the adequate safeguards in place before she comes back to practice law. So I think it has to look at what for the misconduct coupled with the standards is the appropriate sanction.
So just to restate, it sounds to me like you're saying that you believe our analytical process should be first considering the facts and the aggravators and mitigators, what is the appropriate sanction as a first step, and only secondly go to, is this a case amenable to a probation?
Yes, I believe so. I think we look at those standards and say, where does this case fall? And then based on the type of misconduct and the probation plan, is it then appropriate for probation?
So would you say that this is not an appropriate 3-year suspension and then probation in lieu of suspension?
My recommendation is 6 months because I think that's the appropriate length of suspension for the misconduct in this case. I do recognize why Mr. Ambrosio asks for a longer sentence or sanction. I know that he'll discuss that. But I believe this is a 6-month suspension and then the requirement of the reinstatement hearing. I believe I'm out of time. I'll just, if I may briefly just note, I believe that that's appropriate because of the misconduct in this case. We've got the dishonest conduct coupled with other misconduct. I didn't even get into that, but we've got competence, diligent, fee issues, safekeeping property, issues and dishonest conduct, both with candor towards the tribunal and to the clients, causing actual injury. So I request a 6-month suspension.
Let me just follow up because I'm thinking historically here because I understand that probably is that one consideration is that we just consider the length of suspension, what is appropriate under the facts. But there's also this other notion that I think that has kind of percolated through all these cases where we have a longer term of suspension, and that is kind of the kind of notion, let's hold that over the respondent's head. If there's something significant that happens in the probation, he or she is going to have a lengthy term of suspension. So you're kind of thinking that latter kind of idea is not appropriate?
In this case, and that's kind of hard because I don't think probation is appropriate in this case off the bat. I also don't think the probation plan complies with 227. So even, if we said a 3-year suspension, suspended for 90 days, and then with this probation plan, I don't think that's appropriate. But I think that when we're looking at attorney discipline and we're asking this court to impose a sanction, it should be the sanction that we believe is appropriate for the discipline. Does that answer that question?
Yeah. 2 follow-up questions. Well, okay, I forgot what one of them was. Okay, you said it doesn't comply with 227, the probation plan. Can you just remind me?
So 227 requires that the probation plan be workable, substantial, detailed, and provide adequate safeguards to protect against the misconduct. And in my review of the probation plan, I think it's more overview. There are several conditions in it. It's several pages long, but if you really look at the kind of nuts and bolts of the conditions, I'll talk with my practice supervisor about calendaring practices. There's nothing in here to talk about fees, fee agreements, how she's going to properly keep like contemporaneous time records, any of that. There's nothing about taking on only areas of law in which she's competent. And then, of course, the bigger, concern that I think I really talked about at the hearing was the dishonesty and how do you supervise that and what verification is required in a probation plan. So in my view, the probation plan lacks really those adequate safeguards to protect her clients against and herself against future misconduct.
Okay.
What if we took into consideration the additional conditions the panel or the recommendations of the panel, added those on top of the probation plan? Does that change your view of it at all?
It does not, because we're still not that maybe helps with some of the concerns about the dishonest conduct. I still think that that's a difficult situation in any case, and this court pointed that out in Stockwell. But then we're still missing anything about fees. We're missing anything about competence, and those just aren't contained in there to be able to say these are the concrete, detailed things that the respondent is going to do to protect her clients from future misconduct.
I remembered my other thing. And in your recommendation to the hearing panel, you recommended the 6 months suspension and a reinstatement hearing. Is that still what you're?
Yes.
Okay.
And the purpose of that reinstatement hearing would be for her to be able to indicate what she has put in place. And again, I'll take this from the Kupka case where the court talked about ensuring a respondent has in place in their personal and professional life, adequate safeguards to protect against future misconduct. And without seeing that in the probation plan, that's what the disciplinary administrator's office would want to see at that hearing. Thank you.
Thank you. Mr. Ambrosio?
John Ambrosio, on behalf of the respondent, may it please the court, counsel. I wrote down this morning something that I thought of, and I'm glad I did after some of your questions. In one of your decisions, I think it was one of my cases, Janowski, you indicated your job as a court was to help salvage careers. Now that I believe it was in your decision. I've always thought that that was my job when I took on defending lawyers in these type of cases. Now, I will never get to my argument, which is why I love questions so much. What do we do to pay the money back? I've got money in my trust account, not all of it, but I'm willing to set up a plan which he pays back whatever amount of money you deem should go back to those people. The victims in this case, we're willing to do that. There is no vehicle at this time. This is off the record, and I apologize to my colleague about this, but I had my client talk to the probate judge. And the probate judge indicated if the court directs me to have a hearing, since this estate is closed, to determine what should be your fee, I will do that. So I hope your decision has in it, by the way, the judge, you need to reopen this case just to determine what her fees were. Now, let me tell you how these fees came about. I got involved in this case late, even before some of the investigation was completed. And the investigator indicated to my client, when she was unrepresented, I can't decide how much you should have charged in that probate case. And I understand the probate judge sets those fees. That's part of what she did wrong here. So he had her put together a record after the fact as to how much time she has there. And yes, there are a lot of review. But if you look at my time sheets, in the case that's going to be in February, you'll see review of certain transfer, review of this, review of that. That's not unusual. I understand why it's in there. And I understand it should say TC with X, Ray, upcoming hearing, TC with Jones. I understand that. It was not detailed. It was cobbled up after the fact. And that's a valid point. And that's why we need to have somebody determine what a fair fee is to salvage her career. And my colleague is right. I want longer probationary periods because I don't want conduct in this case and other cases to happen from my clients again and again and again. I like holding something over the head.
You mean suspension period?
What did I say?
Probation period.
Okay.
You mean?
Absolutely.
Can I ask
Justice
you-
Rosen, you're right. Even I occasionally misspeak.
You're an advocate for these.
Absolutely.
And so.
And on that point, I totally understand from your perspective as an advocate. And I'm not going to ask you to set aside your advocate hat
Well, can't happen.
necessarily.
It won't happen.
But I will ask you to consider that this is a precedent setting and a precedent abiding court. And so I just want you to comment on the potential problem of that, where let's say we adopted your agreement, or we adopted your recommendation in this case. So it's a 3-year suspension. A few years down the road, the next case comes up, and remarkably, it is like on all four legs.
Okay.
It's almost identical. And we look in our precedent, and our precedent says this is a 3-year suspension. When maybe in reality, it's only a 6-month suspension. That's a problem, isn't it?
Not for me.
I understand, and that's why I asked you.
Not for me, it's not a problem.
Well, but this court is going to be rendering a judgment
I
on your
understand that.
recommendation, so persuade
Could be
me,
for a future
persuade
case.
me that it's not a problem.
It could be what Justice Stiegel is saying. It could be for one of your future clients. It could be major your problem.
It's conceivable, but in this case, I hear what you're saying.
Well, I want to give you an opportunity to persuade me why my concern is misplaced.
And I can't, in all honesty, I can't tell you that your concept is misplaced. I can't do that.
Well, even in this case, though, if she has a 3-year suspension that is stayed for a 3-year probationary period, and she violates terms of the probation, a week or 3 months after such an order is implemented, then she's suspended for 2 3/4 years.
The disciplinary administrator's office, if that occurs, is obligated to file a motion or an application, and we have a hearing in regard to that, is my understanding of the way it works.
And why would we reverse our decision then? I mean, we would of course consider whatever happened, but then we have on the books that, well, we thought a 3-year suspension was appropriate, so now you have to rebut that. Right?
I hadn't thought of this before today. I really don't have I'm being honest with you. I don't have a good answer. And I usually can be glib enough to give you an answer and everything, and I don't have an answer. It's not misplaced. I hear what you're saying. I do think there was probably a family disagreement here that I don't know that's going on. I hear what you're saying. I don't know. But let's look at this case and why I want in this case a 3-year suspension, because I want it held over her head. I don't want this conduct to continue, and we can't handle it with a shorter suspension. Frankly, I'm not sure I will ever file a motion for her to get off probation at the end of that 3 years. She may come to me and say, John, just don't file. And if I don't file a motion to end that suspension, it continues until she dies or until she stops practicing law.
Don't you get the same thing if you have a 6-month suspension that stayed for 3 years?
Okay. Okay. These are, and yeah, maybe a problem down the road, but I worry about these problems on this case, and what happens later, I decide how to handle it then. But I want you to just think about something else. She'll pay back whatever restitution you want. But I want to get to the important part of this case, other than this analysis of what you're supposed to do and what the discipline should be. My colleague asked for a 6-month suspension, which doesn't help at all in this case. It slaps her on the hand. We have a reinstatement hearing. The panel once again says she's reinstated with the probation plan. So she's been punished, but we don't address in any way what led us here. The conduct that was visited upon my client, and read the testimony, that led to PTSD, and led to anxiety, and led to depression. The sexual abuse that I won't mention because we're recording this was visited upon this woman by her father, her mother, her uncle, and his wife that went on for years. It's amazing that this woman went to college and got out, went to law school and got out, practiced law for all these years. We need to look at that in this case. I don't care what you do on these other issues. I want you to look at it.
Okay, so I understand that what happened was horrific.
Absolutely.
Right. I mean, there's no dispute about that. I mean, I don't even know the details, but horrific. But she went 37 years, I mean, with a blip in 1999. She went 37 years and she wasn't dishonest. She didn't engage in knowing misconduct. I mean, so I mean, it's.
We're seeing people come forward, Your Honor, now, 36 years after they were sexually abused, when it suddenly hits them. It certainly hits them like a sledgehammer. What was visited upon them? The I-2 movement.
Okay, so that's a mitigating. What do you do though about the ABA standards? Okay. Which is suspension is generally appropriate when a lawyer knew or should know that she's dealing improperly with client property and causes injury. Or that's 4.12, 4.42. Suspension is generally appropriate. You know, I mean, really what you're asking for is a suspension, but that it be stayed.
That's correct. And that's not addressed in those ABA standards, is it?
Well, why should it be stayed?
Because of the mitigating factors. That's why it should be stayed, because how this woman has worked her whole life. We're lucky she's alive. Every time I get a call from them, I'm hoping it's just to say, John, can I do such and such? It's not, I'm considering suicide again, or I'm considering running my car into a
Well,
bridge.
doesn't that exactly show why she should be suspended?
No, that shows why she should be given a chance.
Please don't talk to me like that.
Oh, I talk to everybody like this, and if I apologize, I was just, this is why I'm Italian and I'm loud. And
No,
when I disagree,
that's not how you treat the court. This is completely inappropriate. I don't let my children talk to me that way, but I'm sitting up here in a robe and you're screaming at me. That is inappropriate.
If I was screaming at you, you would be right, Your Honor. I was loud. I was being an advocate. And if you took it the wrong way, most people would
I
apologize.
took it the wrong way.
Well, that's what, you obviously did take it the wrong way. But it's not about me, we're about her right now. My client would like to address the court. May she?
She may.
Susan.
I appreciate the chance to address the court today. I would first like to apologize to the Andrades and the Casanovas. They deserve better, and at the time I was not able to provide it. Events had overtaken me, and I was unable to do better and not able to see what I was doing. I fell far short of what they were entitled to expect, and I could not even see it. I'm grateful for this entire process. This complaint started in 2021. The behavior that was complained of was from 1919 through 2022. In going through this complaint process, working with my attorney, speaking with my psychologist, working with my practice supervisor, going to resiliency group through KLAP, working through getting the right medications in the right amounts for my depression and anxiety, keeping on a strong path, seeing my practice monitor. I have not been alone. And I'm grateful for that. This process has shown me not just where I went wrong, but where I am now going right and how to keep going right. Discipline means correction and teaching, and I have learned much about the practice of law and people's kindness through this. The generosity of our profession has been so warming for me. I love practicing law. Over my career, I have litigated insurance antitrust cases, Miller Act cases in federal court, fraud cases in commercial construction work, fraud in employment law, airplane repair and home building, construction disputes of government projects. There's nothing like wrestling a verdict from the facts and seeing some measure of fairness done for clients who put their trust in you. Nothing. I am most proud of working in family law. I've been a family law attorney almost exclusively for the last 15 years. I was counsel in a number of cases through the 2010s where this court's ruling in Frazier versus Goodshall was used to support and obtain rights for gay persons to parentage of their children. I've had great satisfaction in child in need of care cases protecting children from ill treatment, which is something that didn't happen for me. I've had the great privilege of shepherding families through divorces and made it my practice never to add anything to the process as a lawyer that would keep a family from being a family on the other side of the divorce process. To me, it's the most important area of law, domestic law, because it is where most people have their only exposure to the legal system, and it is critical to be fair, kind, and thorough. It is a privilege, and I've been grateful for the chance. I can't imagine what else I would have done with my life. I hope you've seen me today for who I am and not just what I've done, but what I can and hope to do. If you have any questions for me, I'd be happy to answer them.
You reserve 3 minutes.
Madam Chief Justice. Justice Standard and Justice Biles, I wanted to address the legal fees, and Justice Paul, you might also ask me about where the information was. I'm looking at Disciplinary Administrator Exhibit 11. It can be found at Bait Stamp 162 of Volume 3 of the record. And this is what I could picture in my mind. But the top of it says legal fees to Carolyn Sue Edwards, and this was created by the client. This is where I got my assumption that it was paid out of the estate. It shows the date that the check was paid, and then it says account Louis A. Andrade Estate -checking. That was where I got my assumption that that's where it was being paid out of, because we only had evidence on aggravating and mitigating at the hearing because of the stipulation. We never asked those specific questions of whether that's how they were, qualifying it for themselves or whether that's actually where that was coming from. But that's where I got my assumption on that payment. I just wanted to briefly indicate that the purpose of lawyer discipline is to protect the public. It's not a slap on the wrist or something like that, a punishment to have a suspension. And that in this case, in light of not just the dishonest conduct, but that of course makes it difficult for supervision, but in light of the other misconduct, the 2 complaints, the actual injury to those clients coupled with the ABA standards, it is our office's position that a suspension is appropriate. And then in light of all the testimony and the mitigating information, coupled with the concerns that led to the misconduct, we're asking for that reinstatement hearing to ensure, and using her therapist to testify at the hearing, that she needed consistent and proper support to help her. And his concern is that she would not easily then fall back into old patterns relating to the trauma of shutting down or simply appeasing situations that shouldn't be appeased, so that we would want to see that at a reinstatement hearing to ensure the protection of her clients and so that she could then return to the practice of law. Thank you.
The court will take this matter under advisement. This does complete our docket. Now. All right.